I'm here with Kevin Sullivan, a member in the Employment, Labor, and Workforce Management practice at EBG, who is going to explain the California employment laws with a focus on wage and hour. Kevin, thanks so much for being here.
Thanks for having me, Dan.
Can you explain what AB5 is and how it's being factored into the Olson versus California decision on independent contractor misclassification?
Yeah, AB5 was enacted in response to the California Supreme Court's decision in Dynamex in 2018, which adopted for nearly every claim here under the California Labor Code a three-factor test, what we know as the ABC test. And specifically, a hiring entity must meet each factor in order to show that a worker is properly classified as an independent contractor rather than an employee. The A factor, that the worker is free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance of the work and in fact. And the B factor, that the worker performs work that is outside the usual course of the hiring entity's business, and the C factor, that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. Now, why AB5 is important, it went into effect in January 2020, and thus AB5 and that ABC test that hiring entities must show in order to establish an independent contractor relationship rather than employee applies to claims arising on or after January 1st, 2020, unless there's an exemption from AB5. And that's where we have Olson. And so the plaintiffs in Olson alleged that they were not treated equally, or they and similarly situated workers and companies were not treated equally by the legislature, such that there was an equal protection violation, because, as the Olson plaintiffs allege, there were all these exemptions, and very unique exemptions, and very many exemptions that carved out from AB5, and thus that ABC test, that carved out these types of workers or those companies from having to meet that test. And the plaintiffs allege that these sorts of exemptions were sort of lobbied for and reached through backdoor dealings, and that those exemptions really don't make sense, or there's no legitimate or rational basis for those exemptions. And the best example that they highlighted, considering the app-based type gigs, is that there was an exemption for app-based gig companies that provide errand type services rather than an exemption for app-based companies that provide delivery or driving services. And the Ninth Circuit appeared to get it right, but that doesn't mean that they agreed that the case has merit or that the legislature was wrong. The Ninth Circuit really just said that, yeah, what the plaintiffs are alleging, if it's true that there were those sorts of backdoor dealings, or that these types of companies over here are being improperly treated, or that there's not equal protection for those companies, that there's no legitimate or rational basis for treating them differently than for other types of workers and companies, then they can state a claim. And so now the case has gone back to the district court level, the trial court level, where the plaintiffs will continue to litigate that, and we'll see what happens.
What are the potential outcomes for California-based companies that hire gig and hourly workers?
Well, right now, it depends on the type of gig. So let's say for app-based companies that offer workers performing errand type services, they're already exempted from AB5. And so they're exempt from that strict sort of ABC test, where a common law test for independent contractor relationship would apply. And it's much easier for hiring entities to meet that common law test. But for companies who don't have those exemptions, the app-based ride hailing and delivery services companies, they're left fighting the fight on multiple levels. One, they're continuing to litigate in the Olson case that AB5 violates equal protection because those companies didn't get those same exemptions. Separately, those companies have been successful in compelling a lot of the plaintiffs in existing litigation to arbitrate their individual claims, presumably with the hope that if the companies prevail in those individual arbitrations, that the companies would then be able to show that that those plaintiffs did not suffer any California Labor Code violations. Why that's significant is because the plaintiffs in these types of cases, they don't bring their claims on behalf of only themselves. They always try to seek to bring their claims on behalf of all other workers on a class basis or a representative basis here under the California Private Attorneys General Act. And so when a company is able to show that that plaintiff did not suffer any labor code violation or was not misclassified as an independent contractor, then that plaintiff would not be able to go and seek to represent other workers.
Can you compare the differences between how classifying gig workers is being handled differently in other states compared to California?
Well, other companies doing business in other states have it a lot easier in general. California in AB5 adopted that ABC test, which is pretty strict and had only been adopted by a few other states. And so for the vast majority of states where there's no ABC test, then companies have a much easier road, let's say, in establishing that an independent contractor relationship, or should I say, that a gig type working relationship is more properly classified as an independent contractor relationship rather than an employment relationship.
California Congressman Mark Takano has reintroduced the 32-hour Workweek Act. What are the chances that this act is made into law, and why did it fail before?
With a Republican-controlled House, I'd say that the chances of that proposed act making out of committee are pretty dismal. As I understand it, when I was introduced in 2021, it didn't even make it out of committee then under a differently controlled House. And the real problem, if I had to speculate, is that on a national level, Congress is not ready to just go and say that overtime should be triggered when an employee works more than 32 hours in a week, or even though not apparent from the name, the proposed act would require overtime when working more than 8 hours in a workday, which is the standard here we have in California. But nationally, Congress isn't ready to do that, and this appears more or less to be an attempt by Congressman Takano to somewhat bypass the prior failed attempts to raise the federal minimum wage, which has been $7.25 for a number of years now. And so this is more an attempt to get more money in employees' pockets for those employees who are subject to the federal minimum wage. But at the same time, Congress isn't ready to do that. They haven't been ready to do that for the federal minimum wage, and I don't see them being ready to do that for purposes of a runaround just to make overtime trigger earlier in the work week or even for a work day.
With over 150,000 recent tech layoffs, San Francisco Assemblyman Matt Haney proposed Assembly Bill 1356 to require 90 days notice for companies with more than 50 employees to give notice. What are the merits of this bill, and will something like this ever pass? And how does it differ from the federal WARN Act?
Well, a few different things there. So California already has its own WARN Act, which is a bit stricter than the federal WARN Act. Let's say for federal WARN, you have 100 employees as the threshold for a company, whereas in California it's 75. Um, I wouldn't be surprised with a Democrat supermajority here in California that something like this passes. The more significant reach, or at least potential reach of the proposed amendments, I would say, is not changing that notice period. Um, Presently in California, it's 60 days. Changing that notice period to 90 days. What's really not talked about enough, I think, is changing the definition of potential employers that this would apply to. Because in prior years, under federal WARN and existing California WARN law, it applies to a covered establishment that would include employees working at an industrial or commercial facility, and it's more in the sense of a single location. But in the proposed amendment, that they propose changing that to essentially an employer with operations where they employ at least 75 persons at a single location or multiple locations. And so you'd have California WARN that would start applying to employers that employ at least 75 persons organization wide, potentially, at least as the proposed amendment is now, rather than employers that are employing 75 persons just at a single location. And so that's the real, I'd say, the more significant piece of AB 1356 is a lot more employers would fall under California WARN than they would have before.
Where does California stand with non-compete employment clauses, and how is it different than the rest of the country?
So for the last 15 years, non-compete clauses and employment agreements or separation agreements have been void in California, and with certain narrow exceptions concerning the sale of a significant stake by an employee. You can have a non-compete provision in connection with that. But most other states generally permit non-compete clauses, although certain states have recently enacted certain laws that walk those, I'd say, that freedom to have non-compete clauses, that walk that back a little bit and imposing restrictions on non-compete clauses. Let's say, for example, if in Illinois, a non-compete agreement might be enforceable if the employee makes a certain amount per year. I think it's $75,000 per year, or if the employer provides sufficient compensation over that non-compete period, if there are widespread layoffs. Federally, there is at least chatter of imposing a non-compete ban, but I don't see Congress getting behind that, or at least anytime soon.
There are several states, including California, that are considering bills to protect individuals from discrimination in employment on account of individuals' familial status. What should we know about this, and will it pass?
Yeah, so it's specific to family caregiver status, and the proposed bill prohibits discrimination based on caring for other family members, that the employee would provide care for other family members, and family members defined pretty broadly to include spouse, child, parent, sibling, grandparent, grandchild, domestic partner, and here's the kicker: any other individual related by blood or whose association with the employee is the equivalent of a family relationship, which is somewhat vague. The prospect of AB 254 passing, I'd say, is pretty good. It's making its way through the various committees. I think it's through 3 committees thus far, all with aye votes. And given that Democrat supermajority here in California, if they want to pass an employee protective based law, they typically will. But California is no pioneer here. Other states already have this on the books: Alaska, Delaware, New York, and a few other states. I believe Illinois, Pennsylvania, and Tennessee also have similar statutes, or at least bills, going through the legislative process. And I can see that happening in Illinois and Pennsylvania, maybe not Tennessee. But at the root, it's trying to accommodate those employees who, as a result of one or more factors, have, and more particularly COVID, but have wound up in circumstances where their caregiving responsibilities have changed and their employment relationship shouldn't suffer as a result. So the legislature's belief.
Artificial intelligence is one of the biggest labor trends right now, and new legislation is trying to protect job candidates from discrimination. What do you think will happen here?
At a national level, it seems too early to say. Here in California, there's already plenty of activity. There's our Civil Rights Council already has proposed regulations regarding the use of AI in hiring decisions. And there's a bill, AB 331, making its way through various committees in the Assembly. I think what you'll see if legislation concerning the use of AI passes is employers will ultimately need to make a decision about whether they want to really continue to use AI, whether that's really beneficial to use AI when weighing against the cost. And that cost really comes down to the strict monitoring requirements that would be in place if AB 331 passed. It would be no light undertaking, the number of assessments that would need to be done, and basically for employers to show that this AI that they would use is not being used in such a way that it's discriminated against employees based on all the different protected characteristics. And so to go and make that showing, which employers would have to do, that might not be worth it.
Yeah.
Just for the benefits of AI. But employers will be making that decision if the bill goes through, and they'll weigh the benefits and the cons.
Yeah, and I'm sure this topic is just going to continue to gain traction as more and more AI is being used for, hiring, firing, just about everything from an employment perspective. And what other California labor laws do you see servicing for the rest of the year, and how will they influence lawmakers across the country?
I think a big one here in California that perhaps hasn't been talked about much is the fast food franchise bill that's making its way through the California legislature. Right now, it's harder if an employee brings a lawsuit against a fast food franchisee. It's harder to impose liability against the franchisor for employment-based claims like wage hour claims or discrimination or harassment. And AB 1228, which is making its way through the committees in the Assembly, would make it a lot easier for employees alleging those types of claims to go and impose liability, if there is liability, against not only the franchisees, but also those large franchisors for those alleged violations. I think you'll see that make its way through, and that could have some consequences, and perhaps stricter controls from the franchisors. It's hard to say. I'm also not going to be surprised if some bill similar to Congressman Takano's 32-hour work week proposed act were introduced here in the California legislature. We already have, again, the overtime triggering at more than 8 hours in a work day or more than 40 hours in a work week. And so I wouldn't be surprised, even though, unlike federal law, California has raised its state minimum wage substantially over the past few years. I wouldn't be surprised to see some bill introduced reducing that 40-hour threshold to 32 hours.
Very interesting. And we will see how these labor laws come into effect. So, Kevin, thank you so much for your time. I'm sure we've all learned a lot more about California labor laws, and there's a lot more to come.
Thanks for having me, Dan.